Good morning. My name is Mark Miner, and I am the Senior Counsel in Thompson Hine's Investment Management and Business Litigation Practice Groups. We would like to welcome you to today's webinar. This is the first in a series of 3 webinars that will be targeting issues that focus on the SEC's recent guidance on common compliance issues for private fund advisors. Before we begin, a few housekeeping measures. First, today's program is being recorded, and we will be sending a link to all attendees within 48 hours of today's presentation. Second, if you have any questions during the webinar, please feel free to use the question box located on the control panel in the right side of your screen to submit the answers. We'll try to answer as many questions as possible at the end of the webinar. I'm delighted to introduce our panelists that will be joining me today. Our panelists include Todd Sipperman, founder of Sipperman Compliance, and my Thompson Hine colleague, Cassandra Borges, a partner in the investment management practice. Todd has over 25 years experience in the investment management industry and helps advisors, broker-dealers, and funds protect their interests against regulatory risk through the development, implementation, and operation of customized compliance programs. Cassandra counsels clients in regulatory and compliance matters, including all aspects of federal and state securities law and related issues, such as registration, regulatory reporting, and private fund and mutual fund matters. With that, let's get started. Our presentation today centers on an OC risk alert that was issued the last week of June. It issued a discussion of observations that it had about private fund advisors' deficiencies that it found throughout its examinations. In this risk alert, OC identified that it conducts hundreds of these examinations each year, but that there are common problems that they find in their examinations. We're going to explore some of those today. The 3 principal findings were conflicts of interest, fees and expenses, and code of ethics violations. We'll be focusing today on certain conflict of interest problems. One of the principal issues that the SEC OC Risk Alert discusses is inadequate disclosure for multiple types of conflicts that arise in the private advisor context. The first problem we would like to discuss is conflicts related to allocation of investors. But before we do that, I'd like to note that the risk alerts have been issued with respect to several prior announcements by the SEC related to private funds, including specific risk alerts about private fund advisors in 2016 and 2017. And here we are 3 years later, and much of the same issues that have been raised in the prior 2 have been raised in this risk alert. So I'd like to begin first with a general question: if there were any impressions of this risk alert that has been recently issued, or the use of OC's risk alerts in general. I'll start with you, Todd.
Yes. Interestingly enough, I sort of felt like it's like watching sports during the pandemic. I wasn't sure if I was actually seeing a live game or it was just a replay of something I saw 3 years ago. And to some extent, when I read this, I had to do a double take because I feel like I've seen this OC alert maybe 5 times since 2012 when Dodd-Frank was first passed, and it's the same set of issues. I'm not really sure what prompted OCIE to issue this risk alert now. Again, maybe they saw some new things that they haven't seen in the past, and I know we're going to talk about some cases, but it does raise the question of whether or not the private equity industry takes the Investment Advisors Act, the OCIE, and the SEC seriously at all. The fact that OCIE's got to keep coming back to these issues suggests that they don't. And I got to tell you, I do this for a living. We're a CCO outsourcing firm, and about 1/3 of our clients we serve as a CCO for private equity firms. And when we talk to prospects, it's astonishing to me. They feel like they're where the investment management industry was in 2005. And I joke, Mark, that there's the 5 stages of compliance grief with private equity firms. Initially when Dodd-Frank was passed, it was, denial. This isn't happening to us. This is going to blow over. It's not going to stay. Then there was anger, which is to heck with them. If something goes wrong, I'll just hire a big law firm and fight it. Then there was bargaining. How little can I do here? There was depression. How much is this going to cost? And then finally acceptance. But I think the private equity industry, is further behind the rest of investment management in those 5 stages of grief. And I think the fact that OCS will issue yet another alert on the same issues indicates that.
Thank you.
I would agree with that. And I would also add, if you recall, before Trump came into office, there was a lot of discussion around repealing and rolling back a lot of these regulations on private fund advisors. So I'm not quite sure if we're at the acceptance stage, Todd, but hopefully we can get there.
Well, we'll be dealing in turn with the many issues that they've raised. As I mentioned, conflicts of interest was the largest of the sections. We're going to deal with certain of those that kept coming up. I think there were a total of 11 different types of conflicts of interest, and we'll be focusing on 3 of them here today. For what it's worth, in terms of the important regulatory meaning for the advisors themselves. So I'd like to start with this discussion around the allocation of investments. Broadly, OCIE has identified inadequate disclosures in the process of allocating investments among the clients. So obviously they are focused on preferential treatments amongst clients. Cassandra, what are some of the preferential treatment concerns that private fund advisors may want to be aware of in this context?
Well, whenever you have an investment advisor, there's a lot of duties and obligations under the Investment Advisors Act. There's a fiduciary duty, which includes the duty of loyalty, care, disclosure, and in the context of allocating investment opportunities, when you have a limited investment opportunity and you have multiple clients, it's important to adopt a solid process and procedure for dealing with decisions around, which client is going into which investment, or how that's allocated among, if you have, an SMA client that is investing pari passu with a fund, how those investment decisions are made and what gets allocated to whom. The other piece of that, of course, is pricing. It also comes up in the context, even if you have a hedge fund with a public security that they're buying, best execution and pricing, prices fluctuate throughout the day. So it comes into play in that context as well. So both with respect to the types of clients and the pricing associated with it. And part of the reason that you adopt policies and procedures on the front end is to try to alleviate those inherent conflicts of interest, perhaps some implicit bias or explicit bias, right? Rogue employees. There's a variety of different situations that you're trying to address via those policies and procedures. So in the context of well, any conflicts of interest, but allocation being among them. I think the first step is to think through what the conflicts are going to be at each stage of a private fund. Obviously, the allocation comes into play when you're in the investment stage, but taking careful, time and planning and addressing all of those issues from, when you're first offering the fund, when you're investing the fund, perhaps liquidating the fund, post issues. If you have a series of funds, there might be a restriction in Fund 1 that Fund 2 cannot start investing until perhaps 75% is committed in Fund 1. But then when you have Fund 2 that's coming into play with a similar investment strategy, you need to be very careful about how those decisions are made, any sort of rescue financing or follow-on investments, which fund they will be going to. There's a lot, there's a lot there to consider. And in terms of policies and procedures, I would say the first, like I said, the first is to identify those conflicts. The second is to develop a process, stick with the process, and disclose what the process is. So those are the key takeaways. And then in terms of compliance, I guess the follow-up piece is do back testing. So once you've adopted a policy and procedure and you've got an allocation, you're definitely going to need an allocation policy. Make sure that you revisit it on a regular basis and that it's actually working the way it should, that you aren't giving investment opportunities to higher fee or higher paying clients. Co-investments, falls into this category as well, but we're going to spend a little bit more time on co-investments in a few minutes. And then with respect to the disclosure, there is a requirement that the disclosure be full and fair disclosure. And that goes to the fiduciary duty, your duty of loyalty. That duty of loyalty is really to put the best interests of the clients above the interest of the advisor. So any sort of proprietary accounts or trading, the client should definitely get. If there's a preference, the client should definitely get it.
Thank you. Todd, did you have any thoughts? As you mentioned, you wrote about a previous risk alert in 2016 where you highlighted preferential treatment as one of the big call-outs by OCIE. And so, here we are again. And so are the clients not noticing them or are they ignoring this canary in the coal mine?
Well, clearly my blog does not get enough readership because it continues to be a problem. A couple of things on that, Mark. It's not like enforcement has not brought cases. I'm just going to cite a case which is sort of a big case in the private equity space in this area. It's Henry James Caird, asset manager. It goes back to 16. I talk about it in my book. It's on my blog. And basically, it was a side-by-side management case. There was a big fund and a little fund. And their policy disclosed that their policy was 2/3 of new issues would go to the small fund and 1/3 of the issues would go to the big fund. Unfortunately, that small fund also included the principal as one of the investors. But really, what the SEC said is that was a problem, certainly. But the bigger problem was that allocation just violated fiduciary responsibility from the jump. That didn't make sense that the big fund. So, this idea, and we'll talk a little bit about this, that and Kassandra's right. As a threshold matter, have a policy. Absolutely, and you got to follow it. But just because you have a policy doesn't mean the SEC is going to be okay with that policy. You also have to take a step back and say, okay, I'm a fiduciary. I can't treat certain clients differently. And there's a ton of case law, except from the Caird case. For instance, outside of private equity, there's a bunch of cases, particularly from the late 2000s, hedge funds going into registered funds and registered fund managers going to hedge funds, where this idea of how investment opportunities were allocated and fairly distributed. There's a ton of cases out there. This is no different. Certainly, when you have a personal investing interest, it raises another set of issues around conflicts. But you're supposed to treat the clients equally, and you got to consider your allocation policy. So I think that's also a piece of it. And I think, as we'll talk about, disclosure is not it's not the cure-all disinfectant that lawyers like to think it is in this context.
We certainly are going to get into a little bit more on that score. Did you have anything to add, Sandra?
Sorry. I was going to say absolutely. While disclosure is very important, I think there are some, you can't disclose away your fiduciary duty. I mean, I've seen, there's some remedies that are put in place. Sometimes an LPAC or an advisory committee of limited partners is brought in to review certain conflicts, potentially some allocation decisions. That helps. But I've seen disclosure from some funds that seem to suggest as long as the LPAC approves it, that does away with any additional fiduciary duty or responsibility, and really it does not. And the other thing to keep in mind with respect to disclosures, you're going to have a PPM or offering document at the outset, and you're going to carefully think through what kind of conflicts there will be, what your allocation policy is going to be, but you can't really predict every single conflict that's going to come up over the course of time. So when those conflicts do come up and they have not been disclosed to your investors, you have some options. You can not do what you really want to do, so you avoid the conflict altogether, right? You can go to the LPAC. You can provide, maybe even go to the LPs for approval. And some of those things can be built into your, not only your policies and procedures, but your governing documents with your investors. But it's careful to think about that ongoing, that full and fair disclosure includes, ongoing disclosure as conflicts develop. I mean, think about what you're going to have in your Form ADV with respect to conflicts. That's an opportunity on at least an annual basis to update that information. But I think part of the reason, that they're keeping the same kind of cases and the same kind of violations is, this can be fairly complicated depending on how many types of clients you have, how many side letters you have out there, and all of the things that the firm and the compliance people need to track. So first and foremost is to keep in mind those specific duties, and pay attention to your policies and procedures, do the testing, and continue to do the best you can.
Mark, I just want to jump one jumping off point, because Cassandra mentioned side letters. As a former in-house lawyer, the thing and compliance person, the thing I hate the most are most favored nation clauses. A lot of private equity have these deals in place with large investors, and it creates all kinds of havoc with your fiduciary duty. You can't really say, well, we have this big client that gets the first crack at all investment opportunities, so go pound sand everybody else. I don't think that's going to fly. And everyone's so eager to bring those big clients in, you sign those things and don't think about the downstream effects, but they are always problematic when it comes to fiduciary responsibility.
I would certainly echo that. From my prior regulatory experience, folks come into an examination or some review with a list of things based on the type of business that you're conducting, and a checklist, which is not something that they need to be slavishly adherent to, but it is a guidepost. But it is a series of if-then statements. Do you do this? If you don't, I'm going to move on to the next topic. Do you use custody? And so if custody is checked, a whole, slew of other questions are asked. And certainly the use of side letters, because they pose these types of risks, are the types of things that cause a whole bunch of other if-then statements to be posed. So I think one of the things that both of you are highlighting is that you have to be familiar with all the ways that the business that you are conducting can raise issues that require careful examination, competent counsel, and frequent review. This is difficult in that much of the criticism tends to be the inadequacy of disclosure as opposed to the failure of any disclosure at all. So as Todd suggested, I think it's always good to have a policy. And so with allocation, Cassandra said, have a policy first, and then we can talk about the adequacy of the policy. So I certainly agree with that. And yet, clear rules of OCIE escape clear definition, or sometimes any definition at all. So the policies and procedures or the disclosures, have to be reasonably designed. And so that doesn't mean that you cover the waterfront, as Cassandra mentioned, but what is that reasonable disclosure? It has to be full and fair. Full and fair is repeated, or at least the definition of full and fair is repeated in lots of SEC pronouncements as that which is sufficiently specific to give the investor reasonable information to make a decision to invest or not invest. So at least you start with that. I also thought it was of note in the risk alert that in clearing the conflicts, the first option that OC recommends is to eliminate the conflict, because it could have said simply to adequately disclose the conflict. So sometimes there may be complexities in the nature of the business for which even adequately disclosing the thing that you are doing will not necessarily get you out of hot water, as we've discussed. So I'd like to go on to the next topic. So OC related that they found routine concerns related to conflicts, related to financial relationships between investors or clients and the advisor. And they describe these generally as inadequate disclosures of conflicts were created by causing clients to invest at different levels of a capital structure, such as one client owns debt, another client owns equity, and a single portfolio company. So what issues are posed by clients investing at different levels of capital structure, and what would be a sufficient disclosure for SEC purposes? Cassandra?
Sure. Well, there's a couple of different things that you need to be concerned about with respect to, those investments at different levels of the capital structure. The first I go back to, the clients that are investing to make sure it's within the investment strategy for the particular client. So maybe there's a client that's looking for debt, another one that's looking for equity. Okay, you disclose that fact that you may have other clients who will invest at different levels. You need to be concerned about the fees. Is there a different, series or class, and there's a different fee structure associated with it? If so, then, why is one client taking the higher fee versus the other? And I would say contemporaneously documenting all of these decisions and your rationale, the same with allocation, is extremely important. And it might be a matter of, timing, availability with respect to one client versus another. So there could be valid, and presumably there are valid reasons that different clients are investing in different parts of the capital structure. But you also need to look at, like I said, any fees or other differences associated with that, whether or not there's any additional benefit to the advisor for one slice versus another one. Make sure you disclose any of those related benefits and the fact that they may exist. And then the other question becomes, when you have a company that's in trouble, and you're going in with debt that's going to be superior to the equity, then how do you address that situation and think about what you need to tell your investors so that the investors, both at the onset and kind of contemporaneously, understand these conflicts are going to arise and what the real risks to them are, and that there may be other advisory clients that, basically get a better result from the same portfolio company.
Todd, any thoughts on that point?
Always, Mark. Yeah. So I think in the PE context, really what this is really about are co-invest vehicles, in my own view. That this idea, who's a more important fund than the other fund. Sometimes you see certain clients get benefited, but a lot of times you see co-invest vehicles. A lot of the case law in this area, I talk about the Caird case, which had to do with certain investment opportunities. A lot of stuff around expenses and how expenses are allocated more heavily toward client vehicles than co-invest vehicles. And again, that's obviously a real problem. It's huge conflict of interest. But, I'm not sure that's disclosable. You can't just say, sorry, clients, our co-invest vehicle, all the insiders are invested, that you don't have access to. Yeah, we're investing the same, but yeah, all those deal expenses and broken deal expenses and due diligence expenses, we're not going to absorb. That's on you. That's your problem. I think that's a real issue. So I see, at least in private equity, it's more around the co-invest vehicles. And when it comes to expenses, I will say I advise our clients, they don't necessarily listen to me, but that, particularly when it comes to taking fees, instead of sort of nicking the portfolio companies and charging consulting fees, tend more toward the traditional asset management model or hedge fund model and charge your 2 and 20 and just leave it at that. Take it all out of that, and that way everybody knows up front, everybody's treated equally. But it's definitely on the co-invest side from a compliance perspective. That's where we focus in this area is to make sure the co-invest vehicle is treated the same as the third-party vehicle.
We are going to, in our next webinar, discuss a lot about fees and expenses, but it probably bears some diving down here. I thought it was of interest that in the prior to risk alerts, OCIE risk alerts on this topic, that the idea of the allocation of expenses was discussed more fulsomely than it was in the most recent risk alert. Does that mean that the problem's solved and institutions don't need to think about that, or the SEC is not focusing on it anymore?
No, not at all. They're definitely focused on it.
If they found more testing, there'd be more results or something like that. No, I think they're definitely focused on. I think part of what you're seeing is an industry thing. I think there's a problem generally in the private equity industry with investment opportunities to begin with. I think from everything you read, there's lots of dry powder out there, a lot of money a lot of money chasing investments. So my guess is there's just not as much volume out there. So it's maybe just less of an issue, but it's definitely a regulatory issue. And I always worry about not what happens today, but what happens tomorrow. I mean, if you look at a lot of the enforcement cases, once Mary Jo White became head of the SEC, a lot of them dated back to practices that occurred prior to 2008. And I think, and I advise all our clients and friends out there that don't assume that the SEC stays static. You don't know who's going to run the SEC and enforcement next year. And that could be this case even if the president doesn't change. You could still have a change in policy at the SEC, and they have a 5-year statute of limitations. So, you got to be thinking about this stuff long term. So even if there's not a huge problem now, if opportunities become more prevalent, this could become a much bigger issue from an enforcement perspective.
I think that's an important point. In thinking about the disclosures, this second topic is one where your admonition, the admonition of the panelists to revisit frequently the disclosure, even if you have described it, is important. Some institutions, unfortunately, regard compliance as not additive to the bottom line, and they come up with a baseline of descriptions of their business, and it comes back to bite them. This specific relationship conflict that they're talking about requires an examination of conflicts that could come up with each individual investor relationship. And so because the raises or the business is not static, those conflicts with respect to this particular topic could be fluid. And so you have to revisit them with enough frequency that you're capturing these types of problems. So what should a disclosure look like in this area? Very often you'll see these kitchen sink approaches where institutions are just covering all bases by describing the types of conflicts that may come up in the context of differing relationships between investors and clients. Does that fly in your experience?
Yeah, the kitchen sink disclosures are not adequate. Now, you might have a little bit of kitchen sink thrown in there for the things that you don't know about, but for any conflict that exists that you're aware of or that you know will exist, you need some specificity. Otherwise, just a broad disclosure is not appropriate, and that's not going to be sufficient for the regulators.
Yeah, I think, I mean, maybe that was as much of a softball mark as you're going to give us today, but I'll just expound on that. I think a couple things to think about how private, there's a huge glitch in the regulatory framework with private funds. Unlike registered funds, you don't have a prospectus updating requirement. Obviously, you got up to the Form ADV, but it's a different document. So very often when funds go live, some deal lawyer at some big law firm has done the PPM and they deliver it, but it's never updated. And I can't tell you how many times from a compliance perspective, the PPM and the practices of the firm are not the same. And not because it wasn't right at the time, but because things have changed. So, I always tell people, have you read your PPM recently? Because it may not reflect what you're doing. Then, of course, you got the Form ADV. So that's one. I think the other sort of big thing to look at, I always get in this conversation with clients, how much disclosure is enough? It's a very esoteric conversation, but there's real world guidance. So as I've said in my blog and in my book, I talk about various private equity cases that have come up in all different areas, everything from allocation of expenses to investment opportunities to monitoring fees, co-invest. There's been a lot of enforcement actions. They will guide you on how much disclosure at the very least is not enough, if not help you. I think to just throw up your hands and say, oh, it's unclear, this should be enough. That's not okay. You should base it in some sort of guidance and case law. And there is a lot out there. Just like when I used to be a straight up securities lawyer and we were doing, Q's and K's and all that stuff. What do we do? Well, there was enforcement cases around 10b-5 and there was examples from other companies. You don't just fly blind. There's precedent. That's how lawyers operate. So there's a lot of cases out there, and I would encourage people that are trying to decide, look at some of those cases and and there's been cases where I said that seemed like enough disclosure to me, and then it wasn't. A good example. I've used this example a million times. Is one of the big cases that came up back in 2015 was the Blackstone case. But I got fined $39 million for those. Don't forget. And it had to do with fee disclosures over accelerated portfolio monitoring fees. Not only was it disclosed, but afterward that they might take portfolio monitoring fees, but it also showed up in the financial statements. And the SEC said that was not enough disclosure. They said you can't just say you might take it when you are taking. You should say exactly what you're taking. And they went a little bit further and said, oh, by the way, you said your LP committee was going to be involved. You should have got approved by the LP committee. But there's an example where just saying you might take portfolio monitoring fees where an ordinary securities lawyer was saying that seems good enough. From a fiduciary standpoint, in the Blackstone case, was not good enough. So there is case law out there to give some guidance.
I think that's very.
And you raise an excellent. Oh, sorry. Go ahead, Mark.
No, I was going to throw it to you. So what do you think about that?
Well, the one point that Todd made that I think is very important is to revisit and update. If you have an ongoing offering, you should revisit and update that PPM at least once a year. If you have some sort of amendment or other material event, it bears updating immediately. And then, keep in contact. And the other thing to think about is to provide those same disclosures to your existing investors. So they're not just going to prospective investors, they're going to the people who are already in the fund. And I'm sure you can come up with a variety of ways to do that. And communication is key. I always tell my clients, take some of those opportunities. It's another touch point with your investors. Even if the message you have to deliver isn't entirely favorable, transparency I think is really important. And the key around all of this, the duty under Rule 206 is, you have to disclose material information and, make sure both when they're making the investment decision and perhaps deciding whether or not to continue to stay in the fund, it's important to provide those material disclosures.
Well, that's a good point. And for the practitioners who are in this every day, they probably know that specific definition, but occasionally you'll get questions from a client even about the materiality. And it's important to note that that definition is not whether that piece of information would have been determinative in a decision. The SEC enforcement case law says that that if that information is important in the total mix of information that a potential investor or investor would make in his decision to invest or not invest, then that meets the materiality definition. And so, I would certainly encourage those who are tasked with that responsibility to think about that broadly. I also thought that the risk alert had an interesting a footnote about highlighting the responsibility of the fiduciary duty that Cassandra was mentioning, and it's separating the requirements of the duty of loyalty and the duty of care. And there are several places in the risk alert and prior risk alerts where it's focusing mostly on the duty of loyalty. This topic too is no exception, but the references all boil down to this: whether or not you're disadvantaging your clients or conducting the business in a way that operates to your benefit or their detriment. And so clearly a regulator looking at any of these relationships is going to carefully examine whether a potential conflict is adequately disclosed, but certainly where a decision would be disadvantaging a particular client to the specific advantage of the institution is going to be severely frowned upon at a minimum, and may be actionable at worst. And so you need to think carefully about those types of issues as you're doing your review. The third topic that I wanted us to discuss today relates to conflicts related to co-investment. We've kind of hinted at this topic. It's come up. It intersects with other topics that we're talking about. But in this specific risk alert, OCIE has specifically identified inadequate disclosure of conflicts created by causing clients to invest at differing levels of a capital structure or other related topics. And so it's defined co-investments. It says that staff observed private funds that had an agreement with certain investors to provide co-investment opportunities to those investors, but did not provide adequate disclosure about the arrangements to other investors. So here we not only have a discussion of the arrangements with the arrangements relating to co-investments, but also a failure to disclose those arrangements to investors who are not participants in some of the co-investment opportunities. Todd, I'll start with you because you were prescient once again, and of the 10 things that you were telling private interest to be concerned about in 2016, this was a highlighted one. And so, again, any thoughts about whether there's something that the institutions are missing? Is it not something that's second nature to them? Why does this issue continue to come up?
Yeah, this one hurts my head a little bit because it seems to me so obvious. So if we were all advising a wealth manager who told you that he buys securities, and when the price is really great during the day, he buys them for his own account, and then when the price goes up later, he buys them for the client account. Well, what do we say? We say that's illegal cherry picking. And in fact, there's a million cases and criminal cases about cherry picking. This really isn't any different from a conceptual perspective. And I think the private equity guy, they just don't understand the difference. And I think a big part of this, Mark, is this sort of distinction between the 10b-5 materiality standard, which you were referencing earlier, and the fiduciary standard. and they're not the same thing. For years, prior to 2012, PE firms, they'd hire a deal lawyer that would draft the PPM and everything was 10b5. That was their standard of care. SEC disagrees with that, by the way. They still say they were an investment advisor, just not registered, but okay, let's not go down that rabbit hole. That's a topic for a law review article. But I think they're still operating that if the deal lawyer said the disclosure was enough, then you're done. But the fiduciary standard of care is much higher than that. It's, as you pointed out, accurately, is a duty of loyalty, duty of care. You're not supposed to be pari passu with your clients. You're actually supposed to be behind your clients. Is really common law fiduciary. They come first. And I really think from a mentality perspective, if you took that mentality, you would understand why favoring co-invest funds is problematic. And when I say that to people, usually it looks like that they just simply can't compute. So I think co-investing will be the one area where it may be the last bastion of private equity that remains down the road on the regulatory side, just because it's such a huge part of how private equity executives get compensated. Getting sort of insider status on these deals. But there is nothing more anathema to a fiduciary duty than basically insider dealing with your own co-invest funds to the detriment of your clients. So I think it's a philosophy thing and a psychology thing, because from a fiduciary standpoint, it's pretty obvious that it's a problem.
Right. Cassandra?
I was going to say, just to lend a little bit of perspective to that, in the private equity community, the view is, listen, these co-investments are good. We've got some skin in the game. We're investing alongside of you. So it does become problematic when they're getting an advantage over their clients. But I think that's the mindset that goes into it. And like I said, and with regards to fees, what we always talk about is, well, listen, if it's just us, it doesn't make any sense for us to charge fees because we're just paying ourselves, right? So you do have to be very careful on the co-investment front, certainly. And there are some egregious things that go on, shifting all of the expenses to the fund and the co-invest fund saying none, that's not permissible. You simply cannot do that. But I think there's some, some good intention behind these co-investments. Which Todd, but there's still a conflict of interest there, and it needs to be appropriately considered and addressed.
Yeah,
sorry. I was going to ask you, what about that, Todd? You have institutions that will come to you and they'll say, look, we have obviously favored nation clients, those that are willing to get in with us on these deals at these specific levels, and why can't I just treat them in this way? And do I have to tell everybody else that's not getting this treatment that they're second-class citizens?
So there's a couple ways, and I am not a deal structure expert. So but I think there's a couple ways, and I think it depends on the situation. So I have seen clients when it's a fee issue. So there's a client that they literally set up a separate fund. So at least you're not co-investing in the same fund and outside. So you have a lower fee fund, and you can do what you do in the regulated industry. Say, hey, look, if you invest more than $10 million, I'm using a number, you can get in this lower fee fund. That's permissible. It's disclosed. There are objective criteria, and if you're not in that category, okay, I've seen folks do that. With allocations, we talked a little bit about that. You can have a disclosed fiduciary policy around allocations that can work. Again, you can do a pro rata based on the investment size. So yeah, a big client could get a larger pro rata share if they're investing pro rata way more. That's perfectly legitimate. So there are ways to structure through that. I think the big issue that I really struggle with some of our C-suite folks and clients is they don't want those policies. They want sort of unfettered discretion to move stuff around and to make deals. And I get it, they're deal folks. But in this world, you really can't do that. You got to set some policies. And like I said, if you set it like, oh look, we have a co-invest fund that has a lower expense numbers, but you got to be at $10 million investments. the smaller clients are not going to really object to that if they're investing in a six-figure range, right? It's pretty obvious that, and you know, people know the way the world works. I think you just got to disclose it, and to some extent restrict yourself from just being discretionary. And I think that's, Cassandra made a huge point earlier about the use of the limited partnership committee. I think that helps you a heck of a lot more, and I think she made this point, than even disclosure. Because if you got a legit independent LP committee approving things, it makes it much harder for the smaller folks to sue or for the regulator to say, you know, you didn't get sign off. And a lot of the cases that are out there, firms had LP committees and didn't get sign off when they should have. So I just thought that was an important point that Cassandra made.
Yeah, the other thing that brings to mind, Todd, and we were talking about this a little bit on our pre-call, you know, with regards to compliance, you've got these big institutional investors, and in large part, sometimes they're driving the compliance more so than proclamations by the staff, because they'll come in with a big due diligence checklist, just like an SEC examiner would, and they're going to go through those documents with a fine-tooth comb, and they're going to look at your policies and procedures, and if they see something that doesn't pass muster, you know, because they're subject to severe scrutiny as well, that's what drives a lot of the changes in the industry, and it's out there and it's real, and you have investors who are paying very close attention. That's another fourth.
I always say that I can't scare private equity managers into hiring us. They're not motivated by fear, but they are motivated by greed. So to your point, when institutional investors come knocking, public plans, sovereign wealth funds, mutual funds sometimes, and are looking to invest, and they're doing their operational due diligence, and they ask a question like, can I see your compliance man, and who's your CCO, and where's last year's 20647 report? And the answer is you know, a bit of a Homer Simpson duh. That's when we get a phone call. I mean, that's most of our PE clients hire us because they're getting pushback from institutional investors. Now, I don't want to say the SEC has no effect, because really those questions from the institutions are being derived from what the SEC requires. So I do think some of these risk alerts, Mark, despite I said it feels like Groundhog Day, that does go into what the institutional investors look for. So I think the SEC is aware of that. So it absolutely has an effect, and maybe more of an effect than enforcement.
Well, and the other thing, the other thing, you know, I think OCIE is more sophisticated. They've set up all of these new branches to focus on specific types of investment advisors or specific issues. They're getting a lot more big data now with everything being automated, all of the filings and cross-referencing that information. So I think the thing that is new, while the messages might not have changed and it's a lot of the same types of violations, I do think the regulators are more sophisticated, as well as the institutional investors.
Well, those are all great points. I think that we, you know, have worked through some of these issues related to disclosure or adequacy of disclosure. I should note that with this co-investment point, if you read the risk alert, this specific section on co-investment, there was a disclosure, and the disclosure that OCIE mentioned was adequate. In this instance, they had a policy about a discussion of allocation, how allocation breaks down, what co-investment opportunities there may be, and how those might affect one group of clients versus potential clients or other clients, but they didn't follow it, right? So here is a very important point. I can tell you that there is no issue that comes up with greater frequency at the very top of these examination findings, but the failure to follow your own policies and procedures. And so a lot of time and attention is placed on making sure that they are fulsome and that they cover all the issues that need to be covered. Sometimes they are best practices. Usually they are rule-based, rules of the road that you have to follow. But there is no easier layup for an examiner to come and just look at the thing that you said that you were going to do, you just didn't do, or you didn't follow. And there's nothing that will make you don't want to kick yourself anymore than having something that's completely preventable. There's so many things where you have to read tea leaves. You're trying to interpret what this requirement or that requirement means, or an institution is actually doing its best to follow certain rules. But in this instance, the finding was that you had a policy. The policy would have been adequate had you simply followed it. Absent some specific rationale for why that's happened, maybe a change in business, maybe it's no longer applicable. That is really a layup. And I've seen regulatory deficiencies where the institution doesn't even really do that thing anymore, but they said that they were still looking for it or monitoring for it in the instances that it happens, and the regulator's not giving up on it so easily. And then, of course, there are issues where institutions, aren't aware of it, and you get a lot more some more latitude than that. But if you've identified a practice that's necessary to include, and you create the policy, and then there is no procedure to ensure that it is followed or adhered to or completed, it's just a completely avoidable deficiency, and you ought not be surprised if in some examination the regulator goes right to those.
Yeah, I know you didn't mean this, but I'm going to, a practical problem I deal with is I've had lawyers actually tell our clients, well, it's better not to have any procedures. That way you can't hang yourself with anything. And the lawyer's view is, all right, we'll just fight it when it comes up. Well, I'd rather fight that we didn't have good procedures than we didn't follow our procedures. And you may win a case in federal court on that basis, but you're not going to win the enforcement action. And so I think that is a very, very risky way to proceed. And I know that's not what you meant, Mark, at all. But I don't want executives out there thinking that the best case scenario is to have and I see this too, just a policy. It'll say we pursue fiduciary principles, and trading, we won't disadvantage any clients, those kind of policies. So theoretically, it's really hard to violate them, but that I can tell you during exams that will not fly. The SEC will hit you hard on your policies and procedures and your testing. So for what it's worth, I just think you got to. I think Mark's point is, at the very least, what I would add to that though is, don't use stock procedures. And we see a lot of that problem. They're not followed, not because the firm doesn't want to follow them, but because the procedures were bought off the web or, given by a consultant 5 years ago, but no one's actually checking to see if that's what's going on in the organization. And very often we find that what's going on in the organization probably is a good policy. Maybe they're doing something really good, but it's just not what's reflected in the paper. And so you got to make sure the two work together. It's an iterative process. So I think, have policy, but also make sure that, you're constantly evaluating that really reflects your operating environment. And that really will solve the problem that Mark raised.
That's an excellent point, and a segue into my final group of questions on this point. I can see that we are coming up on about 7 minutes left in the program. If there's anyone who has any particular question or topic they would like for us to tee up, remember that in the lower right-hand side of your screen, there should be a question box. You pop those in, and we'll try to get them in with the time that we have left. And so, what do we do with all this information? It's probably worth mentioning that the risk alerts themselves all say that they have no force or effect of law. You cannot either, rely on them for any defense or have them used against you. They're simply guidance They are written by OCIE, and yet they're intended to give guidance to specific industries following these examinations that they do throughout the year, and the request from those institutions for feedback on those things that they commonly find that are problematic. And so these risk alerts are usually, the best hits lists, but they are useful. I think, Todd, you raised an excellent point, which is, sometimes we're thinking really defensively about these policies and procedures or practices that we follow against the chance that there may be some regulatory scrutiny. But viewing them as best practices, could put you at a really competitive business advantage if there are two institutions that, a potential client is thinking about using them. So that's a good way to think about them, even if you haven't seen a slew of regulatory actions.
Yeah. It's a small point on that, especially if for what I would call an emerging manager who's already fighting an uphill battle to get an allocation. Large investors are looking for any excuse not to allocate. If you're BlackRock, you can probably get away with a lot, even though I don't think they do. I think, obviously you got brand recognition, but if you're a $2 billion manager who also has a questionable compliance program, it's even more significant.
Right. So with the time that we have left, I wanted to try to handle one specific question. Cassandra, so we're in an environment where there is some regulatory review or some scrutiny that comes up. You're now caught on the web of these hundreds of examinations that OCIE is doing during the year, and you are asked to provide certain documentation that may relate to a co-investment deal or another deal. Do you see contractual agreements that require a notification of other parties before turning over those documents, and how should an institution handle that?
We do see those at times, and typically, there's typically a carve-out to allow you to hand it over to the regulators. But I mean, you just go by the provisions, and whatever the notice requirement is, you go ahead and get prompt notice out. Quite frankly, even if that's not in there, depending upon who the counterparty is, sometimes it's not a bad idea to just give them a heads up in any event. But if you have an examination from the staff, the other point I wanted to make, if the staff comes in and you're preparing your documents and you're pulling them together for your submission, and you discover you have a problem, just address it immediately. And I think if you're better off if you discover that problem on the front end. You say to the examiners, listen, in the course of this is what we found, and this is what we're doing to correct it. That's always going to go over better than just crossing your fingers and waiting to make sure, see whether or not they identify it. First of all, because you do have that fiduciary duty, but it's not. I don't think exams are something to be fearful of. They're going to happen. So the best course is to, be aware of all of, any obligations for disclosure before you hand over exam documents. Keep your annual compliance reviews in good shape and going, regardless of the market environment or the work from home environment, and keep all that documentation current.
Todd, any final advice for those who come under this type of scrutiny?
There we go. It's a little bit like, you hear me now, a little bit like dentistry. You don't want to be going to the periodontist, even though I think that's what Cassandra said. You can fix it at the last minute, but it can be painful and expensive. Whereas an ongoing, legit compliance program, while it may seem expensive, it's really not in the bigger picture. And it also creates good corporate hygiene around things like operations and trading and fees and all the rest of it. So it adds a discipline that's probably worthwhile along. So, my advice is retain a CCO that knows what he or she is doing, or a firm like ours that does this for a living, and let us do our job, and and not have to worry about it. There's people who do this for a living.
Thank you. So in closing, I would like to thank everyone for their interest and their attendance at the webinar today. If you're not currently receiving our updates and our invitations, we invite you to go to the Thompson Hine website and register to receive our mailings under the Publications tab. When today's webinar ends, you will be prompted to take a survey providing feedback. This feedback is very important to us and helps us to continue to tailor our programs to your needs. The next webinar in the series will be hosted on August 12th at 11 a.m. and we will be discussing other conflicts related to preferential liquidity rights, those of service providers, and fund restructurings. Thank you for attending and enjoy the rest of your day. Cassandra and Todd, thanks for your help.
Thank you, Mark. Thanks, Todd.
Thank you. Well done. Are we out?